Now, these are really difficult cases to win, and the reason is something called qualified immunity. Now, qualified immunity is a judge-made doctrine. It's not in the Constitution. It was created by the Supreme Court. Qualified immunity has two prongs to it. The first is you have to show that there was a constitutional violation, and then you have to show that that constitutional right was clearly established at the time of the violation. And courts can consider either one of these things in order. And what this means is, rather than determine whether there was in fact a constitutional violation, courts will just skip to that other piece and say, well, it wasn't clear that that was the law, or it's not clear that that is the law. So unless you have a case that is very close to the situation in your case, some prior case that proves that this has been held to be unconstitutional conduct in the past that would serve to place the state actor on notice that they should not have done this in your case. If you can't prove that, then your case will get thrown out under qualified immunity. Because of what I just explained in terms of it's a two-part test, but courts can skip to the second one, it has really arrested the development of constitutional law in this country, because courts are no longer really required to say what the law is on constitutional rights. They can just say whether the law clearly established X as of a certain date. And they don't have to grapple with, is there a constitutional violation here on these facts, on this case? And so it kind of slows the whole development of the law and makes it much harder to hold wrongful government actors accountable.